Welcome back to the Crypto's Key Conversation. In this video, we're going to take a look at a tweet thread by Johnny Deaton talking about the 16 facts proving the case is dead on arrival, which we've kind of talked about his position on why he thought the case was used as a weapon and the SEC wasn't necessarily going for a sold-out win. They used it to slow down and hinder Ripple and XRP. And then we're going to also touch on Jeremy Hogan's tweet here where he says, when will Ripple versus SEC case end? Ripple thinks it will end sometime between August 26th and November 18th. In its pending class action, Ripple agreed to move the case start back to November 18th and believe that the SEC case will be finished before then. Of course, it can settle anytime. So if we come over here and look at this document he has, it says class certification motion, current date August 26, 2020, new agreed date November 18, 2022. And it says due to the overlap of factual and legal issues between this case and the SC action, the parties agreed that there are efficiencies in having certain aspects of the SC action precede certain deadlines in this action. Doing so will reduce the burden on parties and streamline discovery in this case and potentially reduce the burden on the court by narrowing the issues in dispute. So who knows? He says he wants to thank, Stefan Huber. There we go. I never really paid attention to his at name. Thanks to Stefan Huber for showing this court order to me. It makes me feel more confident in my September summary judgment prediction. I think Ripple thinks it wins the SEC case in September/October, and then this class action goes away due to collateral estoppel. XRP Crypto Wolf says Gary Gensler doesn't want to take a full-blown loss with Ripple, so I believe he's willing to settle the XRP lawsuit, and Brad said they would only settle as long as XRP gets its regulatory clarity. So absolutely, I think that's what everybody wants is we want that regulatory clarity. So coming over here to Johnny Deaton's thread, I read through it and I think it's pretty massive. So he says 16 facts proving the case is dead on arrival. So first, on February 8th, 2018, this is Jesse Powell and Jet McCaleb received a legal opinion letter from Perkins Coie informing them if they sell XRP to investors and use the money for operational costs, XRP will likely be an investment contract, aka a security. So here's a document he put on. I'm just gonna quickly show this. You can pause the video and take a look at it if you like. So coming down here. He says, 2, after receiving the above legal opinion letter, Chris Larson and Jed McCaleb scrap the old business model and instead seek venture capital funding for business operations. Investors will not receive XRP, but instead receive actual shares of stock in the company Ripple. 3, Larson and McCaleb received a second opinion from Perkins Coie on October 19th, 2012. Based on the new business model, they are advised XRP is most likely not a security. The letter hints at risks related to bank secrecy laws and being labeled a money service business. So if we come and take a look at this, you can also pause the video and take a look at that if you want. It's kind of what he screenshotted there. So it says 4, in 2015, Ripple was sued by FinCEN consistent with risks referenced in the legal memo. FinCEN declared a subsidiary of Ripple a money service business and classified XRP as convertible virtual currency. Ripple settled for $700,000 and agreed to register sales with FinCEN. Pursuant to the terms of the settlement with the DOJ and FinCEN, Ripple agreed to register sales of XRP only through FinCEN. The agreement forces Ripple to comply with the banking laws of the United States, not securities laws. So coming down here, you can do the same thing. This is kind of what he pulled up. This is the settlement agreement, and then here goes the attachment B, remedial framework. So coming out here, he says 5, on June 13, 2018, SEC lawyers write a legal memo analyzing whether XRP is a security and does not recommend enforcement. It's clear the SEC own analysis did not conclude XRP was a security. 1, the SEC would turn the memo over. 2, they would have informed Ripple, which they didn't. And we all know that. We've been following it. They didn't. It says 6, the June 14, 2018 Hinman speech, the market absolutely viewed the speech as market guidance, which they've literally said in their own words, in them on video, they were pushing people to the SEC website to view Hinman's speech, and they used that as guidance to whether a token or an asset was considered a security. They utilized the Ethereum free pass speech by William Hinman as guidance. So it's quite clear that that's what happened. And then they're trying to say it was his personal opinion, but now they're saying that it wasn't his personal opinion. It was a part of the corporate finance sector of the SEC. Crazy. So he continues, it says, attorneys Nancy Wotas and Wendy Moore participated in the SEC meetings and described its impact the best. If your platform is slightly more decentralized than ETH, you are free. So we're going to take a listen into this.
What's interesting is I don't think Ether is decentralized. I think it's fully functional, but I don't think it's decentralized. But the chairman, the division director said it's decentralized. So, hey, look at the metrics for Ether. And hey, you do a little better than that, hey.
Then why isn't Ripple?
Yeah, and I wonder if they would have said that 3 years back. I mean, now they came back and said Ether is not, it's not a security, but, it's now. How about 3 years back? Would they have the same answer?
There's no question. Ethereum violated the law in the SEC's view when it issued its tokens. He said that in the speech, even though consensus says, oh, no, that's not what he said. That's what he said. But then he said, look, the securities laws really, it doesn't add anything now because Ether is decentralized. Again, no. Yeah, exactly. So
just yesterday, we played a video of, I showed you a video of Joe Lubin in an interview, and he was super rude to this lady that was interviewing him. And he was pretty much cutting her off, telling her, the SEC never said that, they never said we were security, and they never, treated us as if Ethereum was a security. But, then you have this lady here saying, well, that's what they said. And we've all seen the speech. We've seen them. So it has been evident that, the initial Ethereum in the ICO phase, which they had an initial coin offering, that is a security. It's just a reality. And then you have Joe Lubin of Consensus and, part of this Ethereum free pass. It's like he's literally gloating out there because he got this free pass, and he's being rude about it and bragging about, we've developed this construct and we've created this reality, and Ethereum is scot-free because we've constructed and utilized this verbiage to make it decentralized and yada, yada, yada. It's just crazy that, this gentleman's going around, gloating about everything because he got a free pass, which we have the timeline, and we've literally been piecing together piece by piece of them in their own words and them on video, just almost in a sense making it easy for us. So we're going to continue down here. It says, in the clip above, Wota said, if you can do just a little bit better than ETH, you're golden. Perkins Coie lawyers helped write the Hyman speech, and Wendy Moore, a lawyer from that firm, responded to Wota's comment with, then why isn't Ripple's? That's this lady here. Huge evidence. So yeah, that's absolutely massive. So Wendy Moore, a lawyer from the firm, responded to Wotas, then why isn't Ripple? That's what we're all asking. Like, why isn't XRP have the same pass? Why isn't it declared not a security like William Hyman did Bitcoin and Ethereum in his speech? Continuing on, he says 7. Because Hyman only blessed Bitcoin and Ethereum in his speech on August 20, 2018, Brad Garlinghouse and Joel Katz. You know who Joel Katz is, David Schwartz, the man, the myth, the legend. So it's met with Clayton and Hyman to discuss XRP. Brad informed them Ripple is living in purgatory over XRP's lack of clarity. Continuing on here, it says 8. The next month, September 2018, Garlinghouse met with the commissioner, Elad Roisman. During this meeting, not only did Roisman not inform Brad that the SEC considered XRP security, Roisman made statements that gave Brad Garlinghouse confidence that XRP was not viewed as a security. It's like, okay, well, what is it really? And then it goes down here. It says, Roisman lawyer Esterbrook took notes during the meeting, claiming privilege. The SEC refuses to turn over these notes. It should be noted, however, the SEC provided notes of other meetings between Garlinghouse and the SEC. The notes clearly corroborated Brad's testimony, which we know that, hey, I was given the confidence that XRP was not viewed as a security. Continuing on, it says 9. The January 2019 Coinbase meeting with the SEC, Coinbase and its sophisticated securities lawyers informed the SEC they determined today's XRP not to be a security and intended to list it unless the SEC disagreed. The SEC did not, and XRP was listed on Coinbase in February 2019. So let's pause right here for a second. I'm going to try to be brief. The SEC is there and set out to protect the investors. That's their mission, right? So why not give the regulatory clarity necessary to allow us to have the right information to make an informed investment decision for our families? Then you have Coinbase coming saying, hey, we don't view it as a security and we intend to list it unless, you disagree with whether XRP is a security. And they didn't. So Coinbase listed it, and the SEC didn't stop them from doing it. So why are they contradicting themselves? Why was this lawsuit dropped in the lap? Obviously, we know it was utilized as a weapon. We get all that. But it's like, okay, where is the investor protection at? That's the big question. So coming out here, it says 10. In June 2019, the SEC allowed Ripple to acquire a 9% stake of MoneyGram. Ripple filed a notice with the SEC informing it about its intended use of XRP and MoneyGram. In short, the SEC knew Ripple would transfer XRP to MoneyGram, who would then sell it to retail holders via exchanges. The SEC now claims that XRP sold by MoneyGram to retail holders via exchanges are also sales of unregistered securities. A totally absurd agreement. So yeah, that's what we're saying. It's like they're claiming that even today's XRP and the secondary sales of XRP are securities. They're saying that the XRP that we are investing in, we are held in a common enterprise with Ripple, the company, and we are, expecting a profit or return off of the efforts of Ripple, the company, when we're investing in XRP. Most of us don't even know what Ripple is, let alone, anyone that works on Ripple, obviously outside of, what we see on Twitter and stuff. I know when I first bought it, I wasn't super keen on, Ripple or when I invested in XRP, it was at the top of, coin market cap at the time, and it was under $1. So that's why I bought it, Coming out here, he had put up this document. It says the XRP traded even in the secondary market is embodiment of those facts, circumstances, promises, and expectations, and today represents the investment contract. This is crazy. So coming out here, it says 11. On December 4, 2019, the Financial Stability Oversight Council 2019 annual reports is issued, which classifies XRP a currency. Clayton, as chairman of the SEC, voted to approve the report and signed and signed it. So we're going to take
which they define digital currencies and the addresses listed. So this all started with the SEC and Jay Clayton right before leaving office suing Ripple and its founders. Now let's take a look at this question.
But why is the SEC picking winners and losers? Yeah. Why is a government entity deciding this is a winning one, which by the way happens to have, some pros and cons, massive power consumption, which isn't great for a climate agenda that Gary Gensler cares a lot about, but being silent about other things. And then, and one of the challenges right now is Gary Gensler, who has been asked specifically about ETH, hasn't commented. But if it's so clear, if the laws are so clear and he's asked a specific question, then just answer the question because it's clear.
Well,
And what a great question for Gary Gensler that is. But going back to Jay Clayton's tenure, this is a report from the U.S. Treasury Department, not the SEC, back in 2019, for which they defined digital currencies and the addresses listed and all that they mention here. Among the digital currencies listed in this report, an annual report from 2019 from the U.S. Treasury, it is ETH, Litecoin, Neo, Dash, XRP, and other tokens listed by the prudential regulator, the U.S. Treasury. One has to wonder even more, and shout out to crypto_-ODL for this information, but you have to wonder even more, then why is Jay Clayton's signature on this document either? Because it acknowledges with Jay Clayton's signature, third one down here, that if he understands what the report was that he signed from the U.S. Treasury, then in fact he's acknowledged in 2019 that he believes and also agrees that XRP is a digital currency. Things that make you go,
Things that make you go, indeed. So coming down here, it says 12. In January 2020 and 2021, after the lawsuit was filed, Bellard Inc. and Money Manager Business and perfect example of what a market participant believed, filed an ethics disclosure with the SEC. Bellard assured that the SEC it would only trade the cryptos generally accepted by the market and by the SEC as currencies not subject to regulation by the SEC. The generally accepted currencies not regulated by the SEC are Bitcoin, ETH, and XRP. So if we take a look into this, you can kind of go over and kind of look what's kind of said in here, coming over here. And then you can see this as well. Look, we have Bitcoin, Ethereum, boom, XRP. Crazy. So coming out here, it says 14. I think he deleted 13, I guess. So 14, it says the SEC claims all ongoing sales of XRP are securities, but did not issue a cease and desist against co-founder McCaleb, who has made over $2.6 billion in XRP sales since the lawsuit was filed. Okay, quickly. That's crazy. And we've been following his wallet and all his sales. It's like, why hasn't, if it was really a security and, And that's really the case, and they truly believe that. Why did they allow Jed McCaleb to continue to sell? I mean, look how much money was made off of it. Like, truly, that's I think that's a big negative for, the SEC and their position. Since McCaleb has made $1 billion more than the SEC seeks against Ripple. So we're not going to play that. You can go ahead and take a look at this. Come and see this thread if you want to listen to that. But going on, it says 15. Despite the absurd claim each and every sale of XRP is illegal, the SEC failed to seek a preliminary injunction. If the SEC truly believed today's XRP is a security, would it allow Ripple to engage in ongoing sales of unregistered securities to help pay Ripple's defense? Yeah, like, for real. Like, do you realize that, like, they're still, first of all, there's Ripple's still out there building and expanding. They're scaling their business. They're not, slowing down because of what's going on. They're continuing because they know they're in the right. They have the truth on their side. They're on the right side of law and the right side of history. So they're continuing to do their thing. And what do you think this money's coming from when it comes to them, defending themselves in this case? It's crazy. So then 16 here says, Bragg Ironhouse and Ripple executives like Stuart Alderati, who's their general counsel, and Jabez Schwartz met with leaders of the SEC, including chairman, director of corporation finance, commissioners, and others multiple times, and was never informed XRP was a security except for a meeting just prior to the lawsuit. Wow. He goes, I chose 16 facts off the top of my head to prove the SEC can't win this case as alleged. There's a multitude of other evidence like Christian Carlos, who opt-ed concluding XRP is not a security. But the 16 facts above standalone should equal game over. I mean, you can come in here and take a look at this this Forbes article with Christian Carlo. It says XRP is a security, declares former CFTC chairman. But this is the word right here, game over. We have the truth on our side. The truth will set you free. We're on the right side of law, the right side of history. So I can't wait to see the outcome of this Ripple versus SEC case, and us as XRP community members, crypto members, a part of us that are a part of the class action lawsuit with Johnny Deaton, and the great work from Empower Oversight and Jason Foster and Digital Asset Investor and all the community members and Twitter detectives, Twitter sleuths that's out there fighting the good fight. We're going to prevail. It's just a matter of when, not if. With all that being said, stay strong out there. Be safe.